Hi, everyone, and welcome to the Sentencing Project's webinar. I'm sorry we're getting starting a few minutes late. Thank you so much for joining us. My name is Morgan McLeod. I'm the Communications Manager here at the Sentencing Project. Our webinar today will highlight the Sentencing Project's new report, Delaying a Second Chance, the Declining Prospects for Parole on Life Sentences, which highlights parole policies for people serving life with parole sentences in 32 jurisdictions. We will then hear from advocates in various states working to increase parole opportunities for people serving life. And finally, we will have a Q&A session after all the presenters have spoken. The webinar slides, as well as a recording of the webinar, will be available online, and we will send the link to access those after the webinar. We encourage you all to submit your questions throughout the webinar using the questions panel on the webinar screen. If you look on the toolbar on the right, there's a section called Questions, and you can submit them throughout the discussion. So to begin, I will introduce you to the author of the Delaying a Second Chance report and the Sentencing Project's research analyst, Nazgul Ganoush. Nazgul?
Hi everyone, thanks Morgan, and thanks everyone for joining on this webinar. I want to start by saying that this report was a pretty major undertaking for the Sentencing Project. We got started with data collection in the summer of 2014, and I want to thank my colleagues at the Sentencing Project for helping get us to the finish line, especially Ashley Nellis, who helped with data analysis, Joshua Rovner, Morgan, who's on the panel with us, and previous interns, as well as advocates, experts from around the country who helped get with all the details about the specific jurisdictions that are covered. Today, I want to give you an overview of our findings and recommendations, and also give you a sense of why we decided to do this study and why it mattered. So the purpose of report was to get a sense of why there has been a historic rise in life sentences. So we know from previous research at the Sentencing Project that the number of people serving life sentences has more than quadrupled since 1984, and that's a faster rate of growth than the overall prison population, if you can imagine that to be possible. Even between 2008 and 2012, as crime rates fell to historic lows, in contrast to recent characterizations by the president, and even as the total prison population began to modestly contract, the number of people serving life sentences continued to grow. So we really remain in a tough on crime era when it comes to people convicted of violent offenses, and in particular of very serious violent offenses. By 2012, 1 in 9 people in U.S. state and federal prisons were serving life sentences with and without the possibility of parole. So that's a total of 160,000 people. And most of these individuals, 110,000, were eligible for parole. So how did we get here? We have a sense that the reason there's been such a growth in the lifer population is because of the increased imposition of these sentences, and because of the greater reluctance to grant parole to people who are parole eligible. And so it's the second part that we're really going to focus on. So why does it matter, and how can we convince the public and policymakers that we should revive parole on life sentences, especially given profile of this population? So if we could just go back one slide, the lifer population mostly has been convicted, is there serving time for a serious violent crime. The majority have a homicide conviction, others have other serious violent convictions, though I do want to note that about 10,000 people are serving a life sentence for a non-violent offense, but most of them are there for a serious violent crime. And so the question is, why would we want to revive parole for this population? And to begin answering this question, I think we can consider just the focus on public safety. We know that excessive sentences is not effective for making our communities safer, and that's because most people age out of their crime-prone years. And the quote here shows you that typically what criminologists call criminal careers last about 10 years. And so why would we keep people incarcerated beyond that? One reason some people is to deter others from committing crime. But we know that, in fact, long sentences, and the quote here corroborates this point, are not effective at deterring them from committing crime. And that's because most people are not familiar with the relevant legal penalties. They don't expect to be apprehended. And they sometimes are committing crimes under the influence of substances or while struggling with mental health problems. And so they're not thinking clearly at the time of the offense. Another reason, finally, to scale back long prison terms and revive parole for this population is because we know that it's costly to imprison people, on average about $31,000 a year to put someone in prison. It costs about double that to incarcerate an older individual. And that's money that we could be investing in much more effective crime prevention, drug treatment, and other rehabilitative programs. And finally, we know that extreme sentences like life sentences put upward pressure on the entire sentencing structure. When we sentence people to die in prison, to serve their entire adult years in prison, that makes it seem like 5 years for a drug offense is not a very long time, when actually it's quite a long period of time to spend incarcerated. So now I want to go over with you report and the recommendations that we propose based on this research. So on the left is a cover of the report itself. On the right is a supplementary document which we released, which looks at 32 jurisdictions from which we received data and examines the parole policies and outcomes in those 31 states and the federal government that provided us with some information. So here's an example of what we found. The chart coming up shows you the growth in time served for paroled lifers in South Carolina. So what you can see here is that lifers paroled in 1980 in South Carolina had served just under 12 years, but those who were paroled in 2013 had served nearly 28 years. So that's more than doubling in the period of time that people had served in prison. The next chart shows you a similar pattern in Missouri. And so here you can see the time served increased from 15 years in 1991 to 25 years in 2014. The next set of charts shows you this pattern across 8 jurisdictions from which we received data for the 1980s until the most recent period. And what we found across these jurisdictions was that time served doubled across this period for paroled lifers with murder convictions. And we just looked at murder convictions here to account for any possible change in the composition of the lifer population. So typically people who had a murder conviction served 11.6 years before being paroled in the 1980s in these jurisdictions, and they had served 23.2 years before being paroled between 2000 and 2013, so the long recent decade. I want to focus on California to make 2 points. One is based on this quote from a press spokesperson there who said in 2011 he told reporter Nancy Mullane, most lifers will die in prison before they get out on parole. And in fact, state records corroborated his point. Most lifers with murder convictions, more lifers with murder convictions died in that state than were paroled between 2000 and 2011. And I'm highlighting this because the data that I just showed you are figures on time served for people that were paroled. We don't have information generally on people that are dying in prison or for people that remain incarcerated. We focused on people that were released. The table at the bottom of this slide, though, shows you the number of people that were paroled with murder convictions in California, and you can see that the number went down in the 1990s and remained low in the 2000s, and then started to pick up around 2009. And then even more so in later years under Governor Jerry Brown. And I'm showing this to you because it's important, and what we try to do in the report is to always show you the increases in time served or time served information in conjunction with the number of people released, because that's important as well. So in recent years, California has gotten better and has been paroling more lifers. So what's been causing this increase in time served? We found that 4 factors are relevant. First, it's legislation. Legislators have delayed when lifers can have their initial parole hearings, and they've also increased wait times between parole hearings. So for example, in Georgia, if you were convicted of a serious violent felony and given a life sentence before 1995, you would have had to serve 7 years before having your initial parole hearing. If you conviction and sentence after 2006, you wait 30 years before you can have your first hearing. Another example is in Michigan, for example, where they've increased wait times between parole hearings. So it used to be that if you were denied parole, you had your next hearing in 2 years. And in recent years, it's been that you have to wait 5 years for your next parole hearing. So that's the impact of legislation. Next comes gubernatorial authority. Governors have overhauled the composition of parole boards, who they generally have the power to appoint, in order to reduce parole grant rates. In some states, in particular in some of the states with the heaviest influence, like California, which has over 30,000 lifers, also in Maryland, governors have to approve the parole board's decision for it to be finalized. In states like Arkansas and Wyoming, governors have to commute life sentences before lifers can even go before the parole board. The next factor is parole board decisions, and I think this is what people are most familiar with, the fact that parole board grant rates have gone down, and we've shown that this is the case, especially in the 90s in several states. But what's, I think, notable is that parole board grant rates, you would expect for them to increase, given that parole boards are seeing people much later in their sentences than they had in the past, and yet we generally found that they have gone down or stayed the same, even though their parole boards are seeing people who are served much longer sentences and are at much lower risk of recidivism. The final factor is parole board procedures. Most states, to begin with, granted very limited rights to parole applicants during parole hearings, and some have even further narrowed these rights. So while victims can provide information to parole boards in every state, in several states like Wyoming, South Carolina, Minnesota, the parole applicant cannot actually appear before the parole board in person, but can only communicate via teleconference or video. In states like Kentucky and New Mexico, parole applicants are prohibited from having an attorney represent them at their parole hearings. And in many other states, parole applicants do not have access to legal counsel if they cannot afford to get that themselves. So now, finally, moving on to our recommendations, I want to start by highlighting this quote by Edward Ryan, Joan Peter-Cilia, and Kevin Reitz. They're parole and sentencing experts who draw on heavily for our recommendations. They say extremely long sentences, release eligibility should no bigger than 15 years, in prison for longer than 15 years before they can have their first parole hearing. And I want you to think about what I told you about Georgia, where the legislature requires people to serve 30 years before they can have their initial parole hearing. And I don't mean to, Georgia is extreme, but many other states require 25-year sentences, 20-year sentences, especially for murder. And so many states are really missing the mark in terms of what criminologists recommend for having a meaningful chance of parole. So our recommendation Bill recommended previously, which is to abolish life without parole sentences and strive to limit most sentences to 20 years. So based on the findings of this study, we recommend also that legislatures reduce minimum sentences before initial parole hearings and shorten wait times between hearings, that states work to depoliticize and professionalize parole boards and distance governors from the parole process, that parole boards establish a presumption of release, especially at the initial, but especially at the hearing. So a person should be assumed to be qualified for parole, and the work should be to convince the commissioners that in order to that the person should continue to be incarcerated rather than the other way around. And finally, we recommend improving the integrity of parole hearings, so modeling parole hearings as much as possible after the original sentencing hearing to ensure that the procedural rights of parole applicants are protected. And I'll stop there. Thank you, Morgan.
Thank you, Nazgul. Next, I'll introduce one of our first panelists and have her introduce themselves and tell us a little bit about their work, and then we'll open it up for discussion for a Q&A. So the first person is Barbara Levine, and she's the founder and executive director of Citizens Alliance on Prisons and Public Spending in Michigan. Barbara?
Hi. Thank you, Nazgol, for the extremely well done report and for the chance to participate today. To begin to understand to start with the sentencing scheme. And here the most serious offenses, murder 2, assault to murder, first-degree criminal sexual conduct, armed robbery, all carry a sentence of life for any terms. Judge exercises the discretion to impose a parolable life or numbers. Murder 1 is life without parole. You can also get life in Michigan for certain drug law violations, but they have their own release provisions and are generally paroled when they become eligible. So the figures I'm going to be discussing don't include drug law cases. Once upon a time, Michigan had a pretty progressive parole system. We had a civil service board that was composed of corrections professionals. We had generous good time for people with indeterminate sentences. Prisoners had the opportunity to appeal parole denials to the circuit court. And we had a lifer law that created parole eligibility for anyone who had served 10 calendar years. So whether you had parole short of first-degree murder. So if you had served, whether you had a life sentence or a long indeterminate sentence, you could be considered for parole at 10 years. For lifers, the process was that they were interviewed at 7 years, eligible at 10, and got subsequent interviews every 2 years. If the board is interested in releasing a lifer here after an interview, then they have to hold a public hearing. And notice is sent to the prosecutor and to the sentencing court. One quirk of the Michigan system has been that if a sentencing judge or that judge's successor objects within 30 days of receiving notice of a hearing, the board can't release the person. In the early 80s, the board had release guidelines for lifers and LIDs as long indeterminates. So it had release guidelines for those folks that weren't binding, but they reflected the norms at the time. And it was common that people were expected to be released after serving 12 or 14 years. Judges knew that life didn't mean life, and both judges and the board treated life and long indeterminate sentences as essentially fungible. And judges would even say to a defendant, you know, I can give you a 40-year minimum, and with all the credit you can earn, you can be out in 16, or I can give you life, and you'll be eligible at 10. And people would actually choose life sentences. Little did they know what they were getting into. And the board would then, in those days, apply the same release criteria, which was, you know, whether the people were a current risk. They didn't have a different standard for lifers. All that changed in many of the ways that Nazgol has described. And these changes have trapped hundreds of parolable lifers who reasonably expected to be paroled in the 80s or 90s and are still waiting. First of all, although lifers never got good time, it's important to know that all sentencing credit in Michigan was eliminated in '98. Under Michigan's version of truth in sentencing, people have to serve every day of the minimum. So long indeterminate and life sentences are no longer essentially the same. If you get a 40-year minimum, you have to serve 40 years. The parole board was changed from civil servants to appointees. In the 90s, they were given a mandate to reduce the number of releases of assaultive offenders. Prisoner parole appeals were eliminated, although prosecutors can still appeal parole grants. Crime Victims' Rights Act was amended to allow victims to provide the board with statements or exhibits that cannot be revealed to the prisoner, so the prisoner can never know what's being said or contest inaccuracy. Board interviews here are also now video conferenced. And for lifers in particular, there were changes. First eligibility was changed from 10 years to 15. Subsequent interviews were changed every 5 years. And after that, they were changed from even being required as interviews. They can now do file reviews. A single board member the file and decides whether he or she even wants to interview the person. And they can just be passed over for another 5 years without any reason being given. All the board ever says is no interest. They stopped calculating parole guidelines for lifers, so they don't even do a risk assessment, at least not by the parole guidelines, before deciding, based on thumbing through a file, that they're not interested. At the same time, so for about 12 years, all through much of the 90s and into the 2000s, 12 or 14 years, almost no lifers were released. And the pool of people who were eligible just kept growing. At the same time, minimum sentences for those who got indeterminate terms instead of life have gotten much, much longer. CAPS has done a lot of advocacy around lifers. We published reports in 2004 and 06, again in 13 and in 14. We've done statistical analyses of who the lifers are, historical analyses of how grant rates and time served have increased, and profiles of individual lifers. One thing we also did that we know for a fact has actually had some impact is we produced a statement of support for lifer releases that was signed by 27 prominent former Michigan Department of Corrections professional staff. That included 3 former directors, 2 former parole board chairs, former board members, wardens, and other administrative supervisors that all gave credibility to the effort. In 2007, there was class action litigation claiming that the changed treatment of lifers violated the ex post facto clause. That won in the district court. It was ultimately overturned in the Sixth Circuit. But in the meantime, the district court's orders required to interview hundreds of lifers, and that really helped break the ice. Annual numbers started to go up, but they fluctuated a lot. But in all, in the 10 years between 2007 and 2016, over 230 lifers were paroled. The current board is more willing to proceed, but they now have this pool of currently eligible lifers that we estimated at 935. Nearly a third of them have served more than 35 years, although they were eligible at 10. Another third have served more than 25 years. Well over half are 55 or older. And at the present rate of release, it would take 10 years just to get through half of them. Our advocacy is focused on improving and speeding up the process. We did have a recent success. The governor in the last 2 months, just signed a bill regarding the judicial vetoes that takes the successor judges out of the veto business. Over the years, there were 61 lifers who the board was interested in proceeding on, and they got vetoed by judges. Now, successor judges will still be able to give their opinions, but they will no longer have the authority to prevent release. The next bill that we're hoping will come into play soon, we haven't got it yet, but we're optimistic, would basically restore the old lifer review practice. It'd eliminate file reviews, require personal interviews, restore review every 2 years as opposed to every 5, require the board to calculate parole guidelines and apply the same standards of review to lifers as to everyone else. So that's where we're at here. There's lots more, but I'm out of time. So I just want to again say thank you to Nazgul, because I think the report is really going to provide a lot of credibility for our efforts here.
Thank you so much, Barbara. Next up is Professor Heidi Rummel. She is the co-director of the University of Southern California's Post-Conviction Justice Project. Heidi?
Thank you. Thank you for the report, Nazgul, and thank you for inviting me to participate. California is such an interesting place in so many ways. I'm going to try to give you a brief overview of our process and then focus on inroads we've made to increase the numbers of lifers released through our parole process. A lot of similarities to Michigan, actually. Prior to 1977, everyone in California received a life sentence, 2 to life, 3 to life. Everyone received an indeterminate sentence, and it was routine for people to be released after a relatively short period of time through the parole process. In 1977, the determinate sentencing law came in. That was Governor Jerry Brown, who now I think, or has said publicly he regrets that decision. But at that time, the life sentences were reserved only for murder cases and a few other very violent crime cases. And the maximum you could receive was a 7 to life. That was increased to 25 to life. But over time, we've really expanded the ways in which you can receive a life sentence in California, both through ballot initiatives and legislation, extending it to, we have many enhancements, mandatory consecutive 25 to life enhancements for guns and gangs and various things. So a single homicide now, if it involved a gun and a gang, can, instead of being a 25 to life sentence, is a 75 to life sentence. 3 strikes law affects many people on their 3rd strike, receive a 25 to life sentence, and so on. So I guess looking at the report, we can brag that we have more lifers in California than anywhere else. We have a very robust, compared to other states, a robust parole process. Our inmates seeking parole have a due process liberty interest in parole based on the way our statute is written. So they receive an in-person hearing with 2 to 3 commissioners. They're entitled to counsel. The DA appears. The victims next of kin also have the right to appear at the hearing, and they have, the right to review all the evidence against them, and so on. Everything that you can imagine would come with a due process interest in parole. We also have a presumption in favor of parole, but as you can see by the numbers in the reports, even with the presumption in favor of parole, very, very few lifers make it through the process. Hearings last from 2 to, I had one on Tuesday that was 6 hours. They can go longer. And if you are denied parole, if you're granted parole, we also have a governor has an absolute right to review parole grants or denials, but he only reviews the grants, and there have only been he's since they've had that power. They review the parole grants and have the absolute right to veto or to reverse the grant, still constrained by the laws that create the liberty interest and govern the parole board, but an absolute right to reverse the grants of parole. So it's a very politicized process. To me, that is the biggest obstacle, has been in California, the biggest obstacle to lifers really having a realistic chance of being paroled. Under Gray Davis and Pete Wilson, both Democratic governors, the release rate of lifers was near 1%, less than 1%, 2%, 3%. Under Governor Schwarzenegger, it started to rise. And then Governor Jerry Brown came back into office, and that's been a whole different ballgame for us, although still low numbers, but much, much, much increased from where we had been. So I want to talk a little bit about why I think the numbers are going up, aside from Governor Brown's willingness to both put in place a board of parole hearings that is willing to follow the law and open to releasing appropriate candidates for parole, and his willingness to approve those grants. In 2008, our project challenged a parole denial, and the challenge made it to the Supreme Court of California, the Henry Lawrence case, which retained a some evidence review of parole denials, but expanded the scope of judicial review. And that's, you have to read the case to understand what I'm saying, but really gave the courts a lot more leeway to reverse parole denials. And so we had that case. And then also in 2008, though, the ballot initiative passed that expanded the length, or increased the length of denials for parole hearings. So where previously, if the panel found you were not suitable for parole, they could deny you 1, 2, 3, 4, or 5 years. The Marsy's Law passed in 2008 created a presumption of a 15-year denial, and if you could find by clear and convincing evidence that less time was needed, the board had the choice of a 10, 7, 5, or 3-year denial, but 3-year became the new maximum denial from the 1-year denial that we previously had. And then Governor Brown came into office, and that was sort of a watershed because all the political pressure that had been coming down from the governor's office in who ran the parole board, who was appointed to be a commissioner, what was expected of those commissioners in the parole room, changed. And so that was probably the biggest change that helped us increase the grant rates. But we had 2 very significant legislative changes after Governor Brown came into office that I wanted to speak about briefly, because they have had a huge impact on what's happening inside the hearings and the way commissioners, I think, are looking at inmates who come up for parole and thinking about their crimes and their cases and their rehabilitation. In 2012, we passed Senate Bill 260, which created a youth offender parole process. It's essentially the same process we had in place, but it had two important changes. One is it just created an earlier opportunity for parole and release for anyone who was under 18. Now we tagged this up. We used the Supreme Court and then the California Supreme Court's holdings related to juvenile life without parole to pass this in the legislature. Essentially, we have many people in California under 18 who are serving de facto life without parole sentences. And the Supreme Court in California recognized that the legislature needed to fix that. They said it in a People v. Caballero. So we use that to create this youth offender parole process for those under the age of 18, which would make the minimum eligible parole eligibility either 15, 20, or 25 years, depending on your sentence. And the other very important thing that the law did was to require the board to give great weight to the youth factors that are enumerated in those cases and in the statute. And that it's still being litigated, what great weight actually means and what the board's obligations are, but we have started to see an increase in the grant rates. I know you have Beth Caldwell's really fantastic study in the, and I can't go into why, I mean, it's very complicated as to why the grant rates aren't going up more quickly, but we do see a positive trend and certainly a positive trends inside the parole hearing rooms in the way that the commissioners are looking at the cases, the kinds of training they're receiving, and other things. So SB 260 was very important. It affected several thousand California inmates, but the following year we were able to pass a subsequent bill which raised the age of eligibility from a cutoff of 18 to a cutoff of 23. So, and increased the numbers of California lifers eligible for relief under that law by tens of thousands. So now anyone who committed their crime under the age of 23, with certain exceptions, a few exclusions, is eligible for a earlier youth offender parole hearing and great weight to the youth factors. I know. I guess I'll wrap up with that, and then I'm open to answering questions. There's so much more to say about what's happening with parole in California, but we are moving in a slow but encouraging, positive direction here.
Thank you so much, Heidi. Finally, we have Mujahid Farid, and Farid is the lead organizer for the Release Aging People in Prison campaign. We were having some trouble hearing him earlier, so I just want to check and see if he's here. Farid, can you hear us?
Yes, can you hear me?
Yes, we can hear you. So go ahead, Farid. Thank you.
Okay, thanks. First, I want to thank the Sentencing Project for having the interest and taking the time to prepare and issue this report. I know that I'm not alone in my opinion that this report brings to the forefront the #1 human rights crisis existing in the United States today, mass incarceration. And this report deals with an issue that is right at the heart of the matter. And this issue about the high-hanging fruit, the lifers, is an issue that if we fail to address, that insofar as our successfully attacking mass incarceration, we'd just be whistling Dixie. So I thank I thank the Sentencing Project for this report. It really expresses the real problems that's preventing us from making a lot of progress dealing with mass incarceration. Now, my concern, what I'd like to focus on, is we have this great research from the Sentencing Project and other organizations, individuals, educators, and I think the question before before us is how do we go about using the facts and information at our disposal to bring about the necessary changes. I noticed in this report that the sentencing project noted that in the last 6 years there's been about a 5% progression in decarceration. And I paid attention to that because in looking at, I thought about the people who are trying to decarcerate 50% in the next 10 to 15 years, which is not really a great marker for us to be shooting for, because even if we decarcerated about 50%, the United States would still be the greatest incarcerator on the face of the earth. But in any event, I thought about that, and I said that at that rate that we've been seeing 5% every 6 years, to even reach that 50% reduction, that it would take 60 years. And so I'm wondering if the people who are promoting the 50% reduction have even given that thought, and whether or not they have figured out the type of interventions that need to be employed to change that projection and to get us where we need to be a lot sooner. So I think the task before us, the real task, with all of this great research supporting the need for change, is that we need to be designing, proposing, and executing projects and campaigns that will have a substantial impact on diminishing the carceral state. And all of these that we come up with need to have a reasonable chance of convincing the public and policymakers to adopt them. And so what I'm saying is that we need to operate under the guidance of reasonable possibilities. And on that note, I think I need to say that oftentimes what is unreasonable today or seems to be an impossibility today may not be so tomorrow. The possibilities can grow by increments, by degrees, by steps. And it's often what we do today that can open up the possibilities for tomorrow. And that's really the focus of RAPP. What we've been doing is trying to be creative, extremely creative in the way we approach our efforts at decarceration and think outside the box and to figure out ways that pretty much corral the policymakers in continuing to promote the policies that tend to feed into mass incarceration. We came up with, in the course of thinking of our platform, these were all ideas that we floated, trying to be the voice of reason. And we have certain elements of our campaign, the platform of our campaign, that I often refer to as the voice of reason, or our 5 shiny stones, that we try to push to really corral policymakers to accept the changes that are necessary for us to make the major changes we need in our own lifetimes. Most of us are in the field and not working on this stuff for the next 50, 60 years and not seeing the substantial change that we need to see. And so the biggest question that I have is people that's going to stand up and make decarceration happen, substantial decarceration happen. I think that's something that we really need to be continuing, that we need to continue to push, because as I move about, I really don't see it. I think that there's a lot of focus on reentry and collateral consequences. A lot of great work being done on those issues. Great work, necessary work. But we still, I don't think, have the attention of the activists, the organizations, etc., to make this substantial impact on decarceration. And finally, I'd like to emphasize again that expended energy is not enough. We can expend a lot of energy running on the treadmill. So we do need to, as I alluded to earlier, to set about energy and well-planned, well-thought-out actions that are likely to have a substantial impact. And that's basically what I wanted to present.
Thank you so much, Farid. We're going to open it up to question and answers, and we've got about 20 minutes that we'll do. So the first question, which is going to kind of expand off of Farid's last point, someone asked, is the bipartisan criminal justice reform movement, which exclusively focuses on reforms, well, I won't say exclusive, but mainly focuses on reforms and better supports for people convicted of nonviolent drug offenses, ultimately harm the chances of a more robust, substantive reform movement that includes people convicted of violent crimes and serving life sentences? So anyone can jump in and answer that question if they'd like.
I'm not going to pretend to know the answer to that question or be able to predict it, but I will make an observation about what I've seen in California, which is, and we just passed Prop 57 here, which creates a parole, probably a paper parole process for nonviolent offenders, and requires increased rehabilitative programming in the prisons and that sort of thing under Jerry Brown's leadership. As we make inroads on mass incarceration, almost in any form, bringing programming in, bringing hope. One of the best things all of our reforms have done is just to bring hope that there is a chance for release and incentivize and motivate people to work on themselves and change. There is always a trickle down effect. There's always, there seems to be, I mean, the rehabilitative programming we're going to bring in under Prop 57 targeted at nonviolent offenders is going to be available to violent offenders. When people see others doing good in prison, that, you know, so it's a little mushy-gushy maybe, but I do think that as people look differently at those who are incarcerated, whether they're violent or nonviolent, as the people inside look differently at their chances of being released and what's expected of them when they are released, I think it affects all populations positively.
This is Barbara. I think the other side of what's happening in Michigan is also looking at the fact that people who are serving life in long terms have gotten old and expensive to keep, and if you really want to cut the prison population, you have to address the folks who've committed serious offenses. And I think, you know, one of the strong arguments to be made is about reoffense rates. And ironically, the non-nons actually are more likely to have higher reoffense rates because property offenders do, whereas a lot of murders and other serious offenses are situational and unlikely to be repeated. And the research tends to show that murder and homicide and sex offenders actually have the lowest reoffense rates. So I think if you combine age and cost and recidivism rates, there's still a very strong case to be made for for folks with more serious offenses.
Thank you. The next question is, what can we do about parole boards using nature of crime as a reason to deny parole?
It's interesting. That's the primary issue that we litigated in the In re Lawrence case. Every single crime in every denial, parole denial in the state, every crime was described by the board as especially heinous, atrocious, and cruel, which is one of the unsuitability factors in the regulations. And even under a sum evidence standard, the California Supreme Court held that after some period of time, the crime loses probative value. Current danger is the legal analysis in California, but after some period of time, you can no longer rely on, and good conduct or, demonstrated rehabilitation, the board can no longer rely on the crime to justify a parole denial.
This is Farid.
Yes, we can hear you, Farid.
Oh,
Okay. What we did in New York to focus on that particular issue was to emphasize the fact that when the court sentences an individual, that issue is already taken into consideration, and that is outside the scope of parole authorities to go back and look at the crime itself to make their determination whether or not a person is suitable for release, and that the philosophical approach to parole should be whether or not a person presents a threat to public safety at that point in time that they're being considered. Parole is not, should not be a resentencing process for the nature of the crime. And again, so we try to point out that it should be based on an evidence-based process that takes in consideration risk and needs.
Thank you. The next question, this is for Nazgul. Does the report identify if there are any racial disparities in granting parole?
That's a great question. We looked at the research on that, and the research only looks at parole outcomes in particular jurisdictions, and some studies suggest that there are racial disparities, and others don't find that effect. So I think that there's, the research that's out there is indicative that there are racial disparities. We would expect to find them given that they permeate the criminal justice system, but we cannot say conclusively that they are relevant here.
Next question says, Farid. This next question says, one of the biggest barriers in New York State is that incarcerated individuals must prepare a parole packet to submit to the parole board. Obtaining the documentation for these packets costs money that indigent incarcerated individuals do not usually have access to. Are there recommendations to overcome this barrier? And
Morgan? Hey, Morgan. Sorry, can we put a pin in that for a minute, because our colleague Farid wanted to make a quick comment in response to that racial disparity question that was just addressed.
Sure.
Go ahead, Farid.
Yeah, I'll be very brief. There was a recent report by the New York Times. They did a study in New York, and they pretty much established that there's a racial disparity in parole, the way paroles are processed and the way they're granted. And I think we need to be cognizant that we're going to find racial disparities throughout all of the elements of the criminal justice system.
I would think that we can look at any particular aspect of the criminal justice system and not find some type of racial disparity. Thanks.
Okay, thank you. I don't know, Farid, if you heard the next question, because this was for New York State, but anybody else could answer, but it was about obtaining documentation to submit to the parole board and how it costs money that some people can't afford to, and how we can overcome this barrier.
One thing we've been doing in California very recently is trainings for trial attorneys. We got a favorable decision in the California Supreme Court that at least for youth offenders, which is now up to through age 22, you're required to have a record of their youthful circumstances, and they're entitled to a hearing on that. And we've been doing trainings for trial attorneys saying, here are the kinds of documents to please put in the record at the time following sentencing. And there's a part of our penal code that allows that to happen. And so that hopefully by the time you get to the parole hearing, some of those important materials will be available.
Thank you. And Heidi, also to you, has there been any local opposition or political blowback to the increase of parole grants in California?
Of course, there has. That's always a, it's always a battle, but as I think Barbara was saying, the recidivism rate for released lifers in California is extraordinarily low. I think it's in the low single digits, and most of the reoffenses are not for violent crimes. So it's a back and forth. But yes, there has been pushback and unhappiness with with the fact, not so much from the public as from DAs associations. The prisons are more and more on board. They see that I think that this kind of positive change is actually positive for them too. But that's obviously complicated.
Thank you. The next question asks, should victim participation in the parole process be reconsidered? And another question along the same lines, how should we treat victims or victims' family in this process, and are they the primary objectors to parole reform?
I can just start a little bit with addressing that question. So the quote that I shared during my presentation from Ryan, Peter, Celia, and Wrights, in their recommendations, one of the things that they point out is the goal of a parole board should be to assess future risk of reoffending rather than trying to punish the individual for the original crime. The focus should be on, it should be forward-looking and whether or not the person poses a risk to public safety if they're released. And they point out that victims are very ill-equipped for making this recommendation and giving input on this particular question. Usually they have not, they don't know the individual that's incarcerated. They have not kept in touch with them over time, understandably. And so if, to the extent that we want the parole board to be forward-looking, likely to distort their ability to make that assessment if we're guaranteeing victims have a major input in parole determinations. And I'll let others address this as well.
This is Barbara. I don't think politically you'll ever be able to keep victims totally out of the process, and I think an experienced parole board over time gets to learns how to listen to victims and decides how much credibility to give, for instance, expressed fears that may not be grounded in any real reality as opposed to ones that are. But I think there's a couple of things. First of all, some victims are supportive of parole. And the irony that we see is when victims are opposed to parole, they have lots of credibility with the board. If they support parole, perhaps, for instance, because they're a family member of both the deceased and the prisoner, which certainly happens, or for whatever reason they've gotten to know the prisoner and support release, then they're sort of dupes, and so you want to break through that. In addition, my concern is, as I said earlier, is having whatever victims say be said openly enough so that prisoners get the chance to respond to what may or may not be accurate. And the irony under our Crime Victims' Rights Act is that when the victim speaks at sentencing or gives information to the sentencing judge, the defendant knows that counsel and is able to respond. And yet when information is given years later, there is no opportunity to respond. So I think at least the process has to be made more transparent.
We have a pretty transparent process in California because you're sitting in the same very small room with the victims, almost at the same table when they speak to the parole board. Again, and I totally agree with Barbara, the issue is current dangerousness, and hardly ever does the victim have anything relevant to that decision or that consideration. But in California, they will always, I'm sure, have the absolute right to appear and speak. I have seen in my personal practice over the years that the parole room, despite every obstacle in the way to this, can actually be a place of healing. It doesn't happen often, but it is the one opportunity for people to connect over the event that has probably formed their lives more than any other. What I would like to see happen is some mechanism or method of offering victims, healing dialogue with my client, or restorative justice, or something besides just sitting in the room with the representative from the DA's office who helps them construct their opposition to parole, and is often a very unpleasant and difficult experience for the victims when it doesn't necessarily have to be quite that difficult and unpleasant, but we haven't quite gotten to that point yet.
We have victims, if victims want to appear at the public hearing, at that point they would be in the room and on the record. But public hearing is the end of the process. They're not there during the interview stage, and of course they can contact the board, and as the prosecutors can, at virtually any time and put anything in the file. So,
and you don't have access to the file?
Not to the victim statements. That's the problem. We have full access to the right. Prisoner's institutional file, and can put letters of support and all sorts of stuff in there, but not to what the victim says. And on the other hand, there are plenty of public hearings because they've often come 25, 30, 35, or 40 years after a crime where there is no victim input, right.
Right.
Okay, our final question is there a study available on recidivism of paroled lifers that advocates could use in their advocacy?
I mentioned a couple of these in the report in section 3, and I think this is what Heidi was referring to earlier. There's a study that shows a minuscule, they say, rate of recidivism among paroled lifers in California, so less than a 1% rate of recidivism, and that compares to about a 1 in 3 chance of reincarceration for new crimes among individuals that are other individuals that are released from California prisons. We want to be a little bit cautious about using that because we don't want to, keeping somebody in prison until they have a 1% chance of recidivism, that means we're keeping them in prison for a very long time. And so the goal that we should have in mind is to reduce recidivism rates for everybody that's being released from prison, but we can't expect that that recidivism rates will be close to 0. But what we can know is that the amount of the way that we're using public resources to incarcerate somebody longer than we need to, when they no longer pose an unreasonable risk to public safety, we would be better served investing those dollars in more effective crime prevention programs. And that's what researchers generally say. We have to think about what is the alternative of how we might be using these resources. What would produce, would further incarceration, is that the most effective way of, is that the most effective criminal justice policy? And oftentimes it's not.
This is Barbara. We have the data from Michigan on on the last few hundred who've been released, there have been maybe 3 who've gone back. Only 1, I think, was assaultive. We've got historical data on lifers and on first-degree cases where people had commutations, and again, you know, you're talking 1%. But we also have the data on recidivism rates by offense, regardless of what the sentence was. And I think that's maybe the more useful data, because it goes to the question of, it's not because necessarily people were kept for 35 years or until they were 65 years old, it's because they were convicted of offenses to low recidivism rates. And so, and that helps counter the whole image of these people are going to be dangerous because they committed assault of serious crimes. So, you know, that data is available.
Well, thank you very much to all of our presenters, and thank you so much for everyone who called in. I apologize that we didn't get to everyone's questions, but the contact information for the panelists are included in the slides, so please feel free to reach out and reach out to the Sentencing Project if you have any other questions. I also just want to note that our Director of Advocacy, Nicole Porter, convenes a working group of state organizers and policy advocates advancing state and local campaigns to reform parole systems. Attendees who are interested in learning more should contact Nicole at her email address, which is nporter, P-O-R-T-E-R, at sentencingproject.org, or you can reach out to the Sentencing Project. Again, all of our webinar slides, including the recording of this webinar with the question of answers, will be available online, and we will be sending a link to access this recording and the slides to everyone who registered. Again, a big thank you to everyone who participated.